Okay. Daf Chav Gimel Amid Aleph. We're starting a new parak Zev Borer. This is a very halachically pertinent daf because it deals with actual protocols of selecting and deciding which beit din to go to when there's a difference of opinion. So there's a certain ambiguity in the language of the Mishnah, as you'll see momentarily. Dinei Mamanis Bishlosha. One that is straightforward is that monetary law is decided by three judges, as we learned in the first parak. Ze borer lo echad, v'ze borer lo echad, u'shneim borin lahen od echad, divrei Rabbi Meir. This litigant chooses one, this litigant chooses one, and the two of them choose another. What's ambiguous about this, as we'll see in a minute, is that the Gemara thinks that we're not dealing with choosing a beit din. The beit din is already chosen. You have a beit din. Beit-din are established already. So what does this mean, each one chooses one? It means each one chooses his own beit din. And then we'll see what the difference of opinion. So Rabbi Meir says then the two of them choose a third. But the Chachamim omrim, shnei dayanim borin lehen od echad. And the Chachamim say, the judges, the two judges, choose for themselves another. Now what that means, again, is ambiguous. Let's go on. Ze posel dayono shel ze, v'ze posel dayono shel ze, divrei Rabbi Meir. You know, Rabbi Meir takes a very Western approach. In today's world, when you have two lawyers...
Arbitration?
No, when you have two lawyers that are getting ready for a jury trial, so each lawyer has a right to disqualify a jurist or disqualify a member of the jury, and he can just basically say, I don't like this guy, and he's gone, representing his client. And Rabbi Meir basically takes that approach, that either litigant has a right to dismiss and disqualify any one of the judges that he wants. And v'chachamim omrim, emasai, bizman shemevi alein raya shein kroven opsulin. Avalim hayu ksherin o mumchim ipi beis din, eni yachol aposlan. And the Chachamim disagree. They say, no, that's not how it works. You can't just, on your own, decide that you want to disqualify a judge. There has to be evidence brought to bear that they're either relatives or puzzle for some other reason. And if not, if they're kosher or they're expert judges, you have no right to disqualify them. Similarly, we have a similar machlokus between Reb Meir and the Chachamim as far as witnesses. Ze posel edav shel ze, v'ze posel edav shel ze, divrei Reb Meir. V'chachamim omrim emasai bizman shemevi alein raya shein krovim opsulin. Avlim hayuk sherin eni yochol aposlan. Same machlokus with witnesses. If, let's say, there's a court case, Ruvain is the prosecution, Shimon is the defense, and Ruvain in his witness list says he's going to bring these witnesses. Shimon can't just go ahead and say indiscriminately, I reject that witness. According to Rabbi Meir, he can. And according to the Chachamim, no, you have to bring evidence that that person is puzzle. Otherwise, you can't disqualify them. Let's take a look at the Gemara for clarification. My ze borer lo echad, ze borer lo echad, b'tlas esage. This is a question, an exclamation point. I don't understand. Assuming that we're talking about choosing which beit din to go to, what does it mean? Ruvain picks his beit din, Shimon picks his beit din, and then they choose a third beit din. What do you tell me? You need three beit-din to try one case? With three judges alone is sufficient. Hachi kamer, keshezeh borer lo beit din echad, v'zeh borer lo beit din echad, shneim boren lahen od echad, period. What it means is, and there's a little bit of girsa difference of opinion, but we'll read it just the way it is in front of us, is that when you have an impasse where Ruvain chooses beit din A and Shimon chooses beit din B, and both litigants disagree with each other. You know, Ruvain says, I don't want to go to beit din B, and Shimon says, I don't want to go to beit din A. Then in that situation, they have to choose a third beit din that is mutually agreeable to them both. That's what our Mishnah is saying. So, va'afilu lo v'motzi ma'akev. Now, are you suggesting that even a debtor, if let's say Reuven is the creditor and Shimon is the debtor, then even a debtor has the right to say, I'm not going to your beit din, I'm going to go to another beit din? V'ha'amar Rebbe Lazar lo shanu ela malve, avaloi v'kofen oso v'dan be'ira. Rebbe Lazar said explicitly not that way. He said if Reuven says, let's go to our local beit din, then, and the lova says, no, I want to go to beit din X somewhere else, the lova has no right to demand that. It's only the malva who has a right to demand not to go to the local beit din, but the lova does not have a right. So, Kida Amar Rabbi Yochanan be'erko sheb'sur yashanu, hachanami be'erko sheb'sur yashanu, avol mumchin lo. So the Gemara says you're right. The only time that Rabbi Meir maintains that either litigant has a right to demand not to go to a particular beit din is only when these batei din are not comprised of professional judges. When they're what's called is erkosh of Syria, apparently the custom in Syria was to be tried by a jury of your peers, just like we do in certain societies today. In other words, they would pick 3 judges, but these 3 judges were not professional judges. There was like a trial by jury. And therefore, in that situation, Rabbi Meir says that either party, whether it's a malva or a loiva, has a right to say, I don't like this jury pool, right? But if they're professional judges, even Rabbi Meir would admit that you don't have a right to disqualify. Rav Papa Amar, afilu tema mumchin, kegon beidina de Rav Huna de Rav Chizda, dika amar lei mika matrachna lach. And Rav Papa has a different answer. Rav Papa's answer is no. The only time that we said previously that a lova cannot disqualify a beit din is if the malva wants to go to the local beit din and the lova wants to go to a non-local beit din. Then the lova has no right. The malva has a right to say, I'm not going to the local beit din, but a lova does not have a right. But in a situation where both batei din are local, just like one's in one part of town, the other one's in another part of town, right? Or even if they're next door to each other, just 2 different sets of rabbis, then a lova has a right to say, I'm not going to that beit din, I want to go to the other beit din. Because he could say, I'm not burdening you to have to schlep out of town in order to go to beit din, so I have as much of a right as you do to disqualify that beit din. Now, Tanan. Let's look at our Mishnah. So up until now, we're understanding that our Mishnah is talking about how to choose a beit din. And Rabbi Meir says they have to choose a mutually agreeable beit din. If they can't agree on choice of beit din, they have to keep going until they find the beit din that they both like. So let's look at our Mishnah further in the language. V'chachamim omrim shnei dayanim borin lahed od echad. That the Chachamim disagree with Rabbi Meir, and they say that the 2 judges choose a 3rd judge. Now, v'isal kadaitach kide kamrinan, beit din basar de paslu azlu ubarulahu beidina acharini? Question mark. Now, according to the way that you were interpreting Rabbi Meir's statement, you were saying that when Reuven wants beit din A and Shimon wants beit din B, and they each one disqualify the other one's choice of beit din, they have to choose a 3rd beit din. So what do the Chachamim say? No, the beit din A and beit din B will choose the 3rd beit din. That doesn't make any sense. If they've already been disqualified by the cross litigants, why would they be involved in choosing the 3rd beit din? That doesn't seem to make any sense if they've been disqualified by the other litigants. Va'od mai ze bor lo echad v'ze bor lo echad. And let me ask you another question. If you're telling me that Reb Meir is talking about a case where this is a less than optimal situation, we're dealing with an adversarial situation where Reuven wants beit din A and Shimon says no. Shimon wants beit din B and Reuven says no. So what is that? So the language of each one chooses his own beit din and they disqualify each other's beit din until they choose a 3rd beit din, that's not a lichatchila situation. That's a b'di'evet situation when they can't agree initially on a beit din. So why does the Mishnah use a language of lichatchila? Let each one choose a beit din that will be disqualified by the other. That's not lichatchila, right? So the Gemara's answer is, Ella, you're right. You know what? We have to modify our whole understanding of the Mishnah. We're not dealing with fixed batei din, where the judges are sort of basically already pre-designated. Elahachi kamar, ze bor lo dayan echad, v'ze bor lo dayan echad, and shnein borin lahen od echad. That we're dealing with a beit din that is known as a zabla in the contemporary language. What does the word zabla mean? It's an acronym, ze borer lo echad, and it's based on the language of our Mishnah. we're not talking about a fixed beit-din, and there's a dispute about which fixed beit-din to use. We're talking about where there is no fixed beit-din, or both parties agree that they don't want to go to the already established beit-din, and they'd rather make an ad hoc beit-din. How do you create an ad hoc beit-din? Reuven chooses one dayan, Shimon chooses another dayan, and according to Reb Meir, Reuven and Shimon then choose together, jointly, the third dayan. Maishna da'avdi hachi. So what's the benefit of doing it this way? Amri b'ma'arava mishmei de Reb Zera mitoch shezeh boren lo dayan echad v'zeh boren lo dayan echad u'shneim boren lehen od echad yetzei hadin la'amito. This is because we're doing the selection process in this way, we are more assured of arriving to the truth. Because at the end of the day, since each party is choosing a judge, and then they mutually choose the third judge, we know that they're both going to get a fair shake in court. Each judge is sympathetic, and 2 out of the 3 judges are sympathetic to each of the litigants. And so we know that each one is going to get a fair shake, and eventually there's a sense of equilibrium that is created in that courtroom, so that we hopefully will get a good judgment.
Impartiality, I'm not sure if using the right word, but we're always worried about shaykhid, or someone's got certain pnia toward. So wouldn't you think they should stay out of it? And have 3 judges. And if I choose a judge, then he could suspect, well, maybe this judge owes me something.
Right. So there's actually a machlokus in the Rishonim, is how do you understand what the function of a zabla is. There are some who go as far to say, like Shlomi is suggesting, that when Reuven chooses his judge and Shimon chooses his judge, there's already an assumption that they're partial to the person who chose them. And it's really the third dayan who's basically the sole arbiter. And these 2 guys are acting almost as advocates for their client. That's not really the way the Gemara presents it, but based on your argument that if I'm chosen by that guy, it would seem that I might be, in a sense, partial to him. Listen, we have to hope for impartiality even when I am chosen by someone. But at the end of the day, the reason why we have that third judge is to create that sense of balance, right?
Why does the Gemara go so far away from the pshat of the Mishnah, and then finally getting back to the pshat of the Mishnah?
So if you heard me, I anticipated your question. What I was trying to point out is the Gemara doesn't entertain that you can create an ad hoc beit-din. The Gemara assumes that you're going to a regional beit-din that's already established.
The pshat of the Mishnah is so
That's
clear.
the answer. The answer is because the Gemara didn't think that there was such a mechanism available to a person, and that's the whole question: is a zabla beit-din a lechatchila or is it a b'di'evet? And that also is debated by the Rishon. Okay, one more question, then we've got a lot of ground to cover.
Is what we're talking about right now, is that referring to Reb Meir's statement, or
This is Rabbi Meir. Up until now, we're Reb Meir.
So isn't Reb Meir saying the same thing as the Chachamim?
No, he's not. You're going to see in just a second. Let's go on. V'chachamim omrim v'chulei. The Chachamim say that it's not Reuven and Shimon, the litigants, who choose the third judge, but rather it is the 2 judges who have been selected who choose the third judge. Nema b'derav Yehuda amarav kamiflagi. The Amar of Yehuda amarav ein ha'idim chosman al ashtar ele imkein yodim michosem imohim. Rabbi Meir leslei derav Yehuda amarav v'Rabbanan islahu derav Yehuda amarav. So the Gemara says, let us suggest that there's a machlokus, a fundamental machlokus between the Chachamim and Reb Meir, based on this halachic statement issued by Rav Yehuda in the name of Rav, which is that when you're a witness on a document, you have to know who all of the signatories are before you sign, in order that you don't sign first and then end up with this schlepper who comes along and says, I'm a signatory also. And you're going to say to yourself, oh, if I would have known that I'm signing together with this guy who's a ne'er-do-well, I never would have signed. So that's why you have to know in advance. So the point is like this, that the Chachamim, who say that the Dayanim have a right, have to choose who the third Dayan is going to be, is because they hold it. I'm not going to commit to be a Dayan on a beit-din and have someone else choose the third Dayan without my knowledge. Who knows who you're going to end up selecting? And Reb Meir says, no, it's okay for the litigants to choose the third Dayan, even unbeknownst and without the input of the judges, because we're not worried about that concern. So the Gemara says, lo, the kuli alma islahu de Rav Yehuda Marav, V'das hadayanim kuli alma lo pligi deba'inan. Ki pligi b'das balei dinim. Reb Meir savar das balei dinim nami ba'inan. Rabbanan savri das hadayanim ba'inan das balei dinan lo ba'inan. So the Gemara says, no, that's a misunderstanding. Really, everyone agrees to Rav Yehuda Marab's halacha that no one should be a dayan or an aid unless they know who is participating in that din Torah together with them, who's signing with them or who's judging with them. The machlokus between Reb Meir and the Chachamim is, do you also need the consent of the litigants? Do Shimon and the Reuven and Shimon have input into the choice of the third dayan or not? Rabbi Meir says both the dayanim and the litigants have input, and the Chachamim say no. Once the litigants have chosen their dayan, you leave it up to those two dayanim to choose the third dayan, and the litigants don't no longer have input. Right? Okay. Now Gufa. Amar Rav Yehuda Amar Rav, Ein ha'idim chosim al hashtar v'chulei. So let's go back to this halacha that a person is not allowed to sign on a shtar unless he knows all the other signatories. Tanya nami hachi, kach hayu neki hadash Yerushalayim osin, lo hayichos min al hashtar elim ken yodim michosen mimohen, v'lo hayoshvim bedin elim ken yodim miyoshev imohen, v'lo hayonichnasim b'seuda elim ken yodim mimesev imohen. And the Brisa says that people of clear conscience in Jerusalem, meaning they were very meticulous in their behavior, they never would sign a shtar without knowing who all the signatories are in advance. They would never sit on a beit-din without knowing who the judges are in advance. And they would never sit at a meal unless they know who they're seated with at the table. In other words, it's like you send an invitation to a guy, and Rabbi so-and-so comes back and says, what table are you putting me at? If you don't tell me, I'm not going to be able to come to your wedding. Right? Can you imagine doing the seating that way, David?
I did last night.
Yeah, he's making a wedding tonight. In other words, I certainly would not act this way. I don't think today's etiquette would not really doesn't look favorably at this. But the understanding of it is that a chashuv, a rav, it's not befitting his honor to be seated with amaratzim. Because basically, if you put me next to the amaratzim, I'm guilty by association. They're going to be talking about movies and lashon hara and all these other crazy things, you know. The rabbi's sermon, right? So who needs it, right? So therefore, a person should not sit at a table unless he knows who the people that he's being seated with, so that he can avoid improper conversation, perhaps like Mendel said, or guilt by association. Next, Zeh Poisel Dayan. So in the final analysis, remember we're talking about a Zabla. Next, Zeh Poisel Dayana V'chulei. What about disqualifying a judge? So Reb Meir says that either litigant can disqualify a judge without any evidence, and the Chachamim say no, you need to bring evidence to disqualify a judge. So Kol Kemine de Pasel Dayani. So we don't understand Reb Meir's shita. Since when is an individual entrusted with that much power to be able to just willy-nilly disqualify a judge? So Amar Rabbi Yechanan be'er kosha v'sur yeshanu val mumchin lo. So the Gemara says, you're right. Rabbi Meir is not permitting a person to disqualify an expert judge. He's only talking about those ad hoc courts, or those a court judged by a jury of his peers, like the Assyrian convention, which was to choose a jury of peers to judge you. That's where a person has a right to disqualify, but not expert judges. But wait a minute, Amikatani Seifa, but look at the language of the second part where the Chachamim argue. The Chachamim omrim emasai bisman shemevi raya shein kroven opsulim avalim hayu ksherin omumchim b'fi mipi beis-din eno yachol leposlan michlal de Rabbi Meir mumchin nami ka'amar. One second, the Gemara's language is that the Chachamim say that you can't disqualify someone unless you bring evidence that they're pasul or that they're a relative. But otherwise, a person is not allowed to disqualify someone who is kosher or an expert judge. So you see that if the Chachamim are the ones who argue and say that you're not enabled to disqualify an expert judge, Rabbi Meir holds that you can disqualify an expert judge against what you just said. So the Gemara says, Hachi Kamar. Avalim hayu kesherim naasu ke mumchim mipi beis-din ve'enu yachol leposlan. No, what it means is like this. Rabbi Meir says you can disqualify the jury of peers. And the Chachamim say, no, unless there's evidence that they're no good, any person, even if they're a lay person, is assumed to have the same status as an expert judge. That's what the Chachamim mean. Okay? And Tashma, let's look at a brisa. Amr lo Rabbi Meir, lo kol heimenu sheposel dayin shemum chil. Again, it's problematic according to what you're saying. That in this brisa, the Chachamim turn to Rabbi Meir and say you can't disqualify someone who's an expert judge to the public. So how do you deal with that language? So Ema lo kol heimenu sheposel dayin himchuhu rabim aleim. No, what it means is that a person is not allowed to, or does not have the vested power to disqualify someone that the public has appointed over them to be a judge, meaning a peer. All right? But it doesn't mean that he's an expert. The word mumche means that he's been appointed, not that he's an expert. Tanya nami hachi. Now we have a brisa to support this. The way that we're understanding Rabbi Meir. Now la'olam poso v'holichat sheyakabel of beit-din shemum ch'larabim divrei Rabbi Meir. That Rabbi Meir says explicitly in this brisa that a litigant can passel a judge until an expert judge is appointed. V'ha edim kemumchin dami v'amar Rabbi Meir zeh posel edim shel zeh v'zeh posel edim shel zeh. But wait a minute, I have another problem. Let's look at the next part of the Mishnah, which says that according to Rabbi Meir, either litigant can disqualify the other litigant's witness list. Now, a witness does not have to have expert credentials. Any person, any yid who walks off the street and says, I'm a witness, has the same status as an expert judge. And yet Rabbi Meir says you can disqualify them. There's no less than, there's no lack of credential or lack of qualification in a witness. And so then what gives Rabbi Meir the right for the litigants to, how does a litigant have a right to disqualify that person? So the Gemara says you're right there too. We have to reinterpret that. Ha'itmar Allah, Amar Reish Lakish Peh Kadosh Yamar Davar Zeh Tani Edo. So Reish Lakish says it's impossible that the holy mouth of Reb Meir could have suggested that a litigant can disqualify witnesses. So rather, what he meant to say is that a litigant can disqualify one witness. When there's only one witness who comes forward, the litigant can disqualify him. So the Gemara says, I don't understand. Edo Lamai, what is he coming to testify, this sole witness? If he's coming to testify in a monetary dispute, you don't need him to disqualify the guy. The Torah disqualifies one witness. So, if he's coming to force the other guy to take a shavua, the Torah permits that. So how can the litigant disqualify him? So the Gemara says, La'olam lemamam, Latzricha dekable lekebei trei, and my kamashmalan dematzi hadarbe. So the Gemara says what we're talking about is a case like this. Ruvain is making a claim against Shimon. So Shimon says, I deny the claim. Ruvain says, I have a witness. Shimon says, you know what? You bring your witness, I'll accept him for these purposes like he's two witnesses. The guy shows up and Shimon says, I've changed my mind. He's only one witness, he's not admissible. And Reb Meir says he has a right to do that. He has a right to change his mind. And so that's the Chiddush. But Tanina, we already learned this in a brisa. Amar lo neman alai Abba, neman alai Avicha, neman alai Gimel Roe Bakar, Rabbi Meir Omer Yachol Lachzor, Baba Chachamim Omer Ena Yachol Lachzor. We know this machlokus exists elsewhere. This brisa is talking about judges. Let's say Reuben and Shimon have a dispute, and they both agree that either Reuven's father or Shimon's father can act as one of the three dayanim on the beit-din. Normally he'd be disqualified because he's a relative, but if they both consent, then it's okay. Or let's say they consent to have three farmers act as judges, total laymen who are not experts at all. That's perfectly fine. But in that situation, Reb Meir says the fellow can change, either litigant can change his mind if he's dissatisfied with the way things are going. And the Chachamim say, no, once you've committed to allow this puzzle judge to sit, you can't change your mind. V'amar Rav Dimi b'reida Rav Nachman b'reida Rav Yosef kigon dekable alei b'chad. And that's true even if the other two dayanim are kosher, and it's only one dayan who's puzzle. According to Reb Meir, the guy can change his mind. He said, you know what, I thought that your father would judge fairly. I don't think he's going to be able to judge fairly anymore. I want to have him dismissed. I want to have him disqualified. Rabbi Meir says you have a right to do that. And so the Gemara's question is, why do you need to discuss that here as well? That when one witness comes forward, normally he's not usable, but he says it's okay, I'll use him, he can change his mind afterwards. We already know that from this brisa. So the Gemara says, I'll tell you why. Tzricha. They're really not exactly analogous. The itana abba ve'avicha b'haka ami rabbanan delo matzi hadarbe mishum da abba ve'avicha chazu la'alma. Aval chad kivei trade de la'alma lo chazi ema modu leila Reb Meir. He says, if we only had the machlokas over there where Reuven and Shimon have a dispute, and Shimon says, okay, we'll let your father, Reuven's father, be one of the dayanim, maybe there the Chachamim say, once you've committed to the guy's father, you cannot change your mind. Why? Because since the person is a perfectly valid judge in any other court case except where his son is present, his son is a litigant, therefore we don't allow you to change your mind. But over here, maybe the Chachamim would agree to Reb Meir, because since when is one witness ever acceptable? It's not just that it's not acceptable in this court case, it's not acceptable in any court case that presides over monetary issues. So therefore, maybe the Chachamim would agree to Reb Meir that you always can change your mind when there's a case of one witness. The Iyashmin Baha Ka'amar Reb Meir, Aval Be'ahi Emamodu Lehula Rabbanan Tzricha. And if I only had the machlokas over here, we're talking about where one witness comes forward and initially the other litigant accepted him and then he changes his mind, maybe Reb Meir says he can change his mind only because one witness is never accepted. But in a case where a karov, a relative, is accepted as a judge, since that relative is normally usable for any other court case where there's no relative involved, maybe Reb Meir would agree with the Chachamim that you can't change your mind once you've accepted him. And therefore you need to have both brises, both our Mishnah and the brisa. But wait a minute, says the Gemara. Let's go back to what you're suggesting. You're basically suggesting that we're dealing with a case of where only one witness comes forward, and only in that situation does Reb Meir hold that you can reject him after previously accepting him. Is that what you're saying? But if there are two witnesses, then even Reb Meir would agree that you can't disqualify them? But wait a minute. Hamidikatani Reisha Dayano V'Seifa Edav Alma Davka Katani. But the language doesn't indicate that. As a matter of fact, the word dayan is used in the singular in the first part of the Mishnah, and the word edim is used in the plural in the second part of the Mishnah, so it's clear that the Mishnah knew to be specific and very precise in using the plural conjugation and not the singular conjugation. So it's not so simple, Reish Lakish, for you to change the word witness says to witness, if the Mishnah seems to indicate the other way. So Amar Rabbi Lazar, bibahu va'acher leposlan. So Rabbi Lazar says, you're right. We're talking about either one witness or two witnesses. We'll even say that we're talking about two witnesses. Reuven brings his witness list and he says, I have two witnesses. But what we're also dealing with is where Shimon comes back and he says, it's not just me who's disqualifying your witnesses. I have another person, and he and I are acting as legal witnesses to disqualify your witnesses. That's why we accept it. That's why Reb Meir holds that you can disqualify Reuven's witnesses. But wait a minute. Kol kamini nogeya be'iduso. He's a nogeya badavar. He's a party of interest. He's partial. How can he act as a witness to disqualify those witnesses when he's got a vested interest to make sure they're busted? So Amar Ravacha Bereda Rav Ika Kagon Shekara Alav Ar. The answer is that he lodges a complaint that would, through this complaint, would deem this person unfit to testify. So the Gemara says, well, what are you talking about? Ar demai. What kind of complaint? Ilema ar degazlanusa kol kamini nogea beiduso. If he's going to suggest that, if he's going to testify that this person, the witnesses that you're bringing forward are gazlanim, or one of them is a gazlan, since, again, you got your basic question. How can you admit his testimony when he's a party of interest in this whole case? So, Ella ar to pegam mishpacha. Rabbi Meir savar hani amishpacha kamasadi, v'ihu memela kapasol, v'rabbanan savri sof sof nogea be'idu sohu. Very interesting perspective that the Gemara is suggesting. What we're talking about is where Shimon comes together with a totally outside guy, Levi, and they testify that one of the witnesses that you, Reuven, have brought has a pagam in his mishpacha. He's not fit to act as a witness because his great-great-grandmother was an Eved Kanani, and therefore he doesn't have the status of a full-fledged Jew in order to be allowed to testify in a court of law. That's what I'm testifying. So, again, isn't he a party of interest? So this is the machlokas. Rabbi Meir says, my testimony is about his family, not specifically about him. It's only as a byproduct of my testimony about his great-grandmother that it turns out that he's not usable in this case. So Rabbi Meir says that's admissible, even though I'm a party of interest, because it's a broader testimony than just this specific person. But the Chachamim say, no, if at the end of the day you have a vested interest to see this guy disqualified, then even if your testimony is broader, you still are not, your testimony is not admissible, and you can't disqualify the witness. So here we have another explanation as to what the machlokas between Rabbi Meir and the Chachamim is. Rabbi Meir says, as long as your testimony is broader, which results in disqualification of the witness, we'll allow that. And the Chachamim say, no, we won't. So, Ki asa Rav Dimi Amar Rabbi Yochanan Machlokas B'shtei Kitei Edim. Now we have another approach as to what circumstances Rabbi Meir will allow to disqualify a witness. How can a litigant disqualify? How can Shimon disqualify Reuven's witnesses? So what we're talking about? We ask each litigant, present your witness list at the outset of the case. Reuven comes forward and he says, I have two sets of witnesses. Normally only you need one set of witnesses, but Reuven says, I have two sets of witnesses that are going to testify. I have group A and group B. And so here's what comes along. The Reb Meir Savar Tzarech Levarer, and I'm going to change the girsa now according to Rashi's final pshat. The Rebbe Meir Savar Eino Tzarech Levarer, the Rabbanan Savri Tzarech Levarer. So let me just explain to you what we're dealing with. There's a machlokas that we're going to see shortly. When a person says, here's my list of evidence that I plan to bring to the court case, what if a segment of that evidence turns out to be no good? What happens if a certain segment of that evidence turns out to be no good? Does the court throw out my case entirely? Or do we say that as long as a portion of that evidence is admissible and it's usable against Shimon, Reuven can still act as the victor? So the machlokas is as follows. Rabbi Meir says, if you dismiss one set of witnesses, as long as he can bring a second set of witnesses, no big deal. Because Eino Tzarech Levarer, it's not necessary to bring all of your evidence. Even though you presented it to the court at the outset, you don't need to make good on all of it. So therefore, Rabbi Meir says, if Reuven brings a witness list with two sets of witnesses, Shimon has a right to knock out Group A, and that doesn't destroy Reuven's case because he's always got Group B. And therefore, we allow Shimon to basically say, I don't like Group A, I think that they're not trustworthy people, and I only want you to bring Group B. He has a right to do that. He's not destroying Reuven's case in the process. The Chachamim disagree. The Chachamim say, no, you can't do that. Because by disqualifying Group A, you've totally destroyed Reuven's case. Because once Reuven presents his witness list, he's got to make good on all of the witness groups that he says he's going to bring. And if not, then his whole case is thrown out of court. And that's the machlokas. And that's why Reb Meir allows disqualification only in this case, where there's more than one set of witnesses. So, the Reb Meir Savar Eino Tzarech Levarer, Rabbanan Savri Tzarech Levarer. Aval bekas echas divrei hakol eini yachol leposla. But even Reb Meir would agree that when Reuven only presents one set of witnesses, you can't disqualify them. What right do you have to disqualify two perfectly legitimate people? Amru lefanav Rabbi Ami v'Rebbi Asi, ein sham elakas echas mahu. So now they ask the following interesting question. According to Rabbi Meir, let's say that Rabbi Meir says, when Reuven says he's got Group A and Group B coming to testify, we allow Shimon to say, I reject Group A. Fine, reject it. Now we bring Group B, and it turns out that Group B, one of the people in Group B, turns out to be a relative. So now the shaila is like this. If, before I get into this whole explanation, at face value they're asking the question, what if there's only one set of witnesses? Will Reb Meir allow for disqualification or not? So, Ein Sham Ela Kas Echaz, Amarta Aval Bekas Echaz Divrei HaKol Eni Yochel Aposlan. You just got through telling me that when there's only one set of witnesses, even Reb Meir would agree that Shimon cannot disqualify them. So, Ela Nimseis Kashnia Kroven Opsulin Ma. The question is like this. Reuven said, I got two groups, Group A, Group B. Shimon says, I reject Group A. Court says, okay, we paskin like Reb Meir. Group A, you're dismissed. Reuven present Group B. Group B comes forward, and then we see that one of the guys in Group B is a relative of Reuven, or a relative of Shimon. So now we can't admit it anymore. So now the question is, do we go back and say, bring back Group A, or do we say, once the court has rejected them legitimately, according to Reb Meir, we can't bring them back, and now Reuven's whole case is thrown out of court. So Amar Lahen Kvar Heidu Edim Harishon. So the answer was, sorry, you're out of luck. Once the court has rejected legitimately Group A, if Group B is discovered to have some kind of psul, so then Reuven's case is thrown out. There's nothing he can do about it. Ika Da'amri, others learned that it was Rav Ashi who said that. The Amar Rav Ashi Kvar Heidu Edim Harishon. So now the Gemara says, name of the plukta de Rebbe v'Rebbe Shimon ben Gamliel kamiflagi. Let us suggest that this machlokes between Rebbe Meir and the Rabbanan, the way that you're explaining it now, that we're dealing with where Reuven is bringing forth two sets of witnesses, is the same machlokes as Rebbe and Rebbe Shimon ben Gamliel. The Tanya haba lidon bishtar uvichazaka, nidon bishtar divrei Rebbe. And Rebbe Shimon ben Gamliel omer, nidon bechazaka. Now what happens? There's a dispute between Reuven and Shimon. Reuven says to Shimon, please get off my property. Shimon says, what are you talking about? It's my property. And I have two pieces of evidence. I have a shtar, a deed, that says that you sold me the property. And I have witnesses that I've been living on this property for 3 years. And I'm going to show you when we go to court, I'm going to bring both pieces of evidence. So here's the machlokes. That Rebbe says nidon bishtar, and like Rashi explains, al karchot tzarech lahavi hashtar v'yivarer devaro, that v'im lo yimatz shtar yafsid. According to Rebbe, since you said that you have both a shtar and a chazaka, you've got to present the shtar plus the chazaka. You got to present both. And Rabbi Shimon Gamliel says, no, all you need to present is the chazaka. So the Gemara says, "V'havinan ba b'chazaka v'lo b'shtar." You mean to tell me that if a guy's got both, he doesn't have to produce the shtar? Meaning, so ela'ema af b'chazaka, that you have a choice. You can present whichever one you want. In other words, clearly, a shtar is a greater evidence of ownership than a chazaka, because a chazaka is just that you've been living there for 3 years, but it doesn't show that you purchased it outright, whereas a deed does. So when Reb Shimon Gamliel says, we dafka want you to present the chazaka, it's not to the exclusion of the shtar, but you have the option. Let's say Shimon's claim was, I have a deed and I have a chazaka. And then when he gets to court, he says, Judge, I'm sorry, I couldn't find the deed. So Rebbe says, you're out of court, you lose the case automatically, because you said you have two pieces of evidence, and now you only have one. But Reb Shimon Gamliel says, no, even with one of those evidences, you're okay. So the kaimalan de bitzarach levar pligi, and the machlokus over there is that according to Rebbe, if you said you got two pieces of evidence, you got to make good on it. And Reb Shimon Gamliel says no. Even if you said you had two and you only come up with one, as long as it's valid evidence, that's enough to win the case. So it seems that this is the whole machlokus over here as well. Rebbe Meir will side with Reb Shimon ben Gamliel, and he'll say that even though you came forward initially with two sets of witnesses and now you only have one, that's still okay, you can still win the case. And that's why Rebbe Meir allows Shimon to passel one of Reuven's sets of witnesses. But the Chachamim say no, if you said you got two, you got to bring both of them, and that's why Shimon can't disqualify either of them, because if he disqualifies one, he's disqualified your whole case. So the Gemara says, lo, that's not necessarily so. Aliba de Rabbi Shimon ben Gamliel kuli alma lo pligi. Everyone would agree that if you go like Rabbi Shimon ben Gamliel, you could passel one set of witnesses, and that would be fine. Ki pligi aliba de Rebbe. The machlokus is within Rebbe Shita, who says tzarech levarer, that once you said you have two pieces of evidence, you got to make good on it. Here's the machlokus. The Rebbe Meir kerebbe. Rebbe Meir will hold. I'm sorry. This is the where we have to change the girsa once again. The chachamim kerebbe. The chachamim hold like Rebbe and say that you that once you said you have two pieces of evidence, two sets of witnesses, you got to make good on it. And the Rebbe Meir amrilach ad kan lo ka'amar Rebbe Hassam ela b'chazaka de pikuachnefesh-danger-life ka'asi aval hacha dehani edim lav mikoach edim achrini ka'asu afilu Rebbe Moda de ein tzarech levarer. But Rabbi Meir would tell you like this. In that situation, according to Rebbe, since the shtar and the chazaka are directly related to each other, the shtar is proof of purchase, and a chazaka is proof of that very same purchase. In other words, they're directly linked to each other. The chazaka is a product of my having purchased the property, which is verified or which is evidenced in the shtar. So therefore, if I said I'm going to have both, Rebbe says you need to bring both. But in a case of two sets of witnesses, it could be that Rebbe would agree that two sets of witnesses are not inexorably linked with each other. Just because I said I have group A and group B, and if I only bring group A, nishkaferlach, or if I only bring group B, nishkaferlach, because they're not directly linked with each other conceptually. And therefore, it's not necessarily so that there would be the same machlokes between Rebbe Meir and the Chachamim as there is between Rebbe and Rabbi Shimon ben Gamliel. Now, that's another approach. So again, this next approach has just said that the only time that Rebbe Meir holds that you can disqualify witnesses is if what? Is if there's two sets of witnesses that Reuben wants to bring and you just want to disqualify one of them. There Rebbe Meir says you could and the Chachamim say you cannot. Ki asa Rabin Amar Rabbi Yochanan Reisha be'edim pesulin v'dayanim kesherim migu de pasli edim pasli nami dayanim seifa b'dayanim pesulin v'edim kesherim de migu de pasli dayanim pasli nami edim. So Rabin says I have another approach. This is what the Mishnah is talking about. You know why Reb Meir holds that you can disqualify judges and you can disqualify edim willy-nilly? No, we're dealing in a situation as follows. In both the Reisha and the Seifa, Shimon basically says to Reuven like this: the dayan that you chose is no good, and the witnesses that you say that you have are no good. Now, normally we would not believe him on either claim, but all of a sudden, an independent piece of evidence comes forward in the Reisha to say that the witnesses are puzzle. So because Shimon's claim that the witnesses are puzzle has been corroborated independently, we give him, using the power of amigu, the credence for the judges as well. And the Seifa is just the opposite. That independent evidence comes forward to confirm that Shimon's accusation that the judges are puzzle is taka true. And we say, since Shimon was correct in his claim that the judges are puzzle, we will accept his claim that the edim are puzzle. So that's the only time that Reb Meir says that a guy can puzzle the edim, when there's already power from an independent source that his co-claim that the judges are puzzle has been corroborated. So the Gemara says, wait a minute, so maskif la Rava. So Rava challenges that. He says, Bishlam amigu de pasli edim pasli nami dayani hika beidina achrina el amigu de pasli dayani pasli nami edim v'haedim suleka. I don't understand, says Rava. I can understand that if the edim have been puzzled, will let Shimon also passel the judge. Why? Because you can always get another judge. Judges are a dime a dozen. You can't get Rabbi X, you'll get Rabbi Y. But if we've passeled the judge, what right do we have to believe Shimon to passel the edim? What if Reuven says these are the only witnesses to the transaction? How can you automatically just reject them just because the judge has been proven to be puzzled? So the Gemara says, Lo tzricha dika kasacheres. So the answer is you're right. Even in a situation where the judge has been proven to be a false judge or a puzzle judge, we will only allow Shimon to puzzle Reuven's witnesses when Reuven has more than one set of witnesses. Wait a minute. Haleka kasacheres mai hachanami delomatzi pasli hainu de Rav Dimi. 1 second, says the Gemara. Then you're going back to Rav Dimi's shita. Rav Dimi said that Rav Meir only allows you to passel Reuven's witnesses when he's got more than one set of witnesses. So how are you saying any differently from Rav Dimi? Answers the Gemara, Ika beinayu migu, de marsover aminan migu, marsover lo aminan migu. The machlokas between Rav Dimi and Rabin is as follows. According to Rav Dimi, even if no judges have been passeled, according to Shimon, independently, we still allow Shimon to passel one of the sets of witnesses that Reuven brings forward, as long as Reuven has another set of witnesses. But according to Rabin, even if there's more than one set of witnesses, we will not allow Shimon to passel any of Reuven's witnesses unless he has a migu, which says that there's credibility to his claim because he's already been able to prove independently that one of the judges is passel. So since he's got the power of that migu, that he's passeled the judge, we also give him the power to passel a second set of witnesses that Reuven wants to bring forward. And this is where we'll hold it for today. A little bit complicated. Rabbi Chanan ben Akasha Omer Ratzah.